G'day, this is Andrew Lovett, and today's topic is labour hire licensing laws that have been brought in to legislation by the government recently. I'm really pleased today to have Andrew Wood with us. Andrew is a barrister based in Melbourne, but working right across the eastern states of Australia, Tasmania, Victoria, New South Wales and Queensland. Andrew is a long-standing colleague of our firm. I've worked very closely with Andrew for a number of our clients, as did my father in the firm before me. Andrew is joining us by a video link, and he's in Melbourne today. So Andrew, how's the weather in Melbourne?
Bleak and overcast. I'm thinking of Clancy of the Overflow right at the moment.
Okay, well, it's bright and sunny and lovely here in Brisbane today. So Andrew, let's move into this material. So I guess the first thing is, can you give us a bit of an overview of these new labour hire licensing laws? Who does it affect? Why has the government implemented these new arrangements? And those sorts of things.
Andrew, I think a good place to start would be with a number of the media reports that people would have seen over the past couple of years. The Slaving Away report about labour hire workers being underpaid, being accommodated in overcrowded accommodation, and in some situations being exploited in a number of different ways. That particular report struck a chord, and there were quite a number of Fair Work Ombudsman prosecutions of labour exploitation. There were Senate inquiries, there were parliamentary and public inquiries into the labour hire industry, as a result of which several states have moved to put in place legislation that is designed to do two things. First of all, it's designed to protect workers from exploitation. And secondly, it's designed to improve the integrity of the labour hire industry.
And which states does this new set of laws apply to? And is there anything similar in overseas jurisdictions?
There are two sets of legislation operating in Australia currently. There's the Queensland scheme and the South Australian scheme, both of which are up and running, and both of which are taking applications for labour hire licences and issuing labour hire licences, and Queensland is already moving into its enforcement stage, so it's well and truly down the track. In Victoria, there is legislation before Parliament, currently being debated in the Legislative Council, the upper house in Victoria, and similar legislation has been proposed for the ACT, but it hasn't yet surfaced, so that's perhaps a bit further down the track. There is similar legislation overseas, Andrew. One of the models for, I think, the Queensland and the South Australian schemes was the UK's Gangmasters licensing scheme, and it came about as a result of a tragedy many years ago when a number of shellfish gatherers were collecting shellfish. The tide came in and they drowned, and the UK government moved quite quickly to put in place Gangmasters licensing. Gangmasters being those people who supply workers to another person in particular industry sectors, or alternatively who provide food processing or food gathering or harvesting services in those sectors. So the UK scheme is a bit narrower than ours because it's limited to horticulture, agriculture, food processing, shellfish gathering, but it's also wider because it picks up a number of harvest contractors and people who wouldn't be caught by our scheme because they're recognised mainly as services providers rather than labour hire providers.
And focusing in on the Queensland law and its implementation now, as you say, it's well progressed. What should a Queensland-based labour hire company be doing now? What should they be doing right now?
Right now, it should be applying for its licence if it doesn't already have it. The scheme opened in mid-April. and all labour hire providers in Queensland have to have their licences, or at least their applications in, by the 15th of June. There are over 1,300 applications that have been made to date, and we're about the halfway point. So they should certainly be applying for those licences.
And what should a business that uses labour hire services, so I guess the customer, the client of the labour hire companies, what should they be doing over the now and over, say, the next 6 months?
Andrew, that's a great question. I think because clients also have some responsibilities under the Act, they need to come to terms very quickly with what the nature of a labour hire arrangement is. They need to be able to recognise a labour hire arrangement, make sure that they are only dealing with a licensed provider, and make sure that they can recognise avoidance activity. There are a couple of reasons for that. One reason is that it is an offence under this legislation for a client to deal with an unlicensed provider. Both the provider and the client can be subjected to very heavy sentences around the $400,000 figure mark in round terms, and prison sentences of up to 3 years, again in round terms. And those offences relate to supplying labour hire services without a licence, receiving labour hire services from a provider who doesn't have a licence, and being involved in avoidance activity. Clients also have a responsibility to report avoidance activity that they've been able to identify, or should have been able to identify. The fines are a bit less, they're only $25,000 in that case, but nonetheless, what we're looking at when we're considering this legislation is a scheme that is imposing responsibilities on both sides of the labour hire transaction.
They're fairly heavy fines and sentences. I guess the other thought is, are there any exemptions that might apply? So, for example, if there was some arrangement that was very transitory, very short term, a day or something, or a few days, or if there was a corporate group where one company in the group or one entity within the group, maybe for the sake of an efficient payroll, a group might have all of its employees in one company or one trust or something, and other assets of the business or activities of the business in other companies or entities. Are there any exemptions that apply to those sorts of circumstances?
Andrew, there are some exemptions. There are a couple of exemptions that are included in the Act itself. So somebody who is acting solely as a private employment agent or a permanent placement recruiter rather than a labour hire provider, and that will be a person who places a candidate for employment with their client and the client engages them directly. Somebody who's only doing that and nothing else doesn't need to have a licence because they're separately regulated in Queensland. In relation to the other areas that you mentioned, there are a couple of important exemptions contained within the regulations. But it's important to keep in mind that they don't actually exempt the provider from the need to have a licence. All they do is take the workers who come within those regulatory exemptions outside the definition of a worker. So if one thinks about it, typically a labour hire provider might be providing a range of different workers. Some of them might be receiving very high income. And those workers might be exempt under the high income threshold provision. Some of the workers might be supplied under incorporated contractor type arrangements. So the workers themselves will have their own small incorporated entities, and they will be trading or they'll be working through those entities, and there are a limited number of exceptions that would say that those people aren't treated as workers. There are other situations where an employee who is in ongoing employment, has a reasonable expectation of continuing employment, is seconded from the employer's organisation into another organisation. So, for example, a firm of solicitors in Queensland might have employed a solicitor, and they might have placed that solicitor as on secondment with the government department. For example, work cover, Queensland Health or whatever, for a period of 12 months or so, and that would be considered to be one of the exceptions. The group situation that you mentioned is also an exception, so that employees who are engaged by one entity within a recognisable corporate group and deployed only within members of that corporate group, not outside the group, but work only within it, they will be treated not as being workers. So the entity that's operating the payroll function or the entity that has undertaken the responsibility for engaging those workers will be able to say, well, these aren't workers for the purposes of the Act. Because they're not workers for the purpose of the Act, I therefore don't have to have a licence. But if they're providing workers outside the corporate group, even a single worker for a single day or a half a day, they would have to have a licence. So It is as strict as that.
Yeah, okay. This is all new ground, isn't it? It's never been tested in Australia, so you wouldn't want to be the first person to be subject to the first business subject to being audited or being prosecuted by the government.
Certainly not, Andrew. And I think the legislation, in a sense, is so novel and so loosely developed that when there are prosecutions or when there's administrative action, for example, if action is taken to suspend or to terminate a licence, there will be appeals and a number of the issues that have been unresolved in legislation or the regulations will need to be sorted out by the courts.
Okay. And so if your business fell into the category of a corporate group or, a grouping of trusts or other entities within the one business, what should those business people be doing now to prepare for it's not just prepare, it's actually law now, isn't it?
Yes, it is. I think what they should be doing is looking very carefully at what their arrangements are, looking very carefully to see whether or not all of the corporate members that may be related to each other are operating within a recognisable group. Now, that's not perhaps as clear as one would think, because sometimes a corporate group will have different branding, and the branding will be recognised as though it were a separate business unit, even although there may be single corporate entities behind it. So the test seems to be whether or not the workers are working within something that is recognised as a shared group.
Okay.
So you can think of the sorts of situations in a hospital, for example. The hospital's operation might be seen by the public as being distinct from its research arm, or from some of its other arms, or from some of its specialty functions. Or if the hospital has both a public function and a public-private section, there may be questions about whether or not the private hospital is seen as being a distinct entity from the public hospital, even although there may be elements of common ownership between them. So those are the sorts of things that we would need to look at pretty carefully.
So Andrew, for example, in the tax field, if our client needs absolute certainty, they can apply to the Taxation Office for a ruling. Is there something similar under this new labour hire licensing arrangement that can give business people certainty about this issue?
In Queensland, alas, no. Although the regulator is encouraging inquiries to be made of it, and those inquiries should be made. So if there is any doubt or if there's uncertainty, certainly obtain advice on it, but also get that advice checked out with the department as well, so that there is fairly open and transparent arrangements. And the reason you want to do that is that you don't want to be caught up in anything that somewhere down the track is going to be asserted or alleged to be avoidance.
Yep.
South Australia approached it differently, and they gave their regulator administrative power to grant exemptions. So in South Australia, for example, you would apply for an exemption from specific provisions of the legislation, and then you could test administratively whether or not the exemption should have been granted.
Do you think this system will expand to other states, Andrew? I guess that's a bit of a political question, but what's your feel for that?
Well, I think it is certainly a political question. It's the Labor states that have been to the fore in introducing legislation. There is a doubt, I think, about the extent to which the legislation will be carried through and enforced in South Australia with the recent change of government. The Western Australian government, I think, had indicated some interest in a labour hire licensing scheme, but didn't see it as being on the immediate horizon. There has been pressure, I think, from the states upon the federal government to step into the field and regulate a national scheme, although the federal government has been somewhat resistant to that. It'll be an interesting question, Andrew, to see whether or not the federal government's hand is eventually forced by having several different state schemes operating, each of which have their own curiosities, their own areas of difference, their own nuances, that will simply make it difficult to transact business in a single national economy.
All right, well, thank you so much for allowing us your time today, Andrew, to talk these important issues through. It's quite a minefield, and it's a big risk for some clients. I think it's time to act for a lot of clients, for a lot of businesses now, to be certain about this issue.
Yes, it is. And they should also always seek advice from people who are familiar with their structures, familiar with their operations. Speak to people such as yourself and get a sense of where they might start, because the organisational structure is at the heart of what's taking place here.
That's another tax insight from LOVETTS. If you'd like more information about this important and very current topic, please get in contact. Our contact details and Andrew Wood's contact details will appear now.